had a chance to speak with the alleged victim on it. My understanding is that the state's not going to seek pretrial detention, and we're essentially going to do ask the court to set a bond today. I'll just be asking the state's going to ask for the court to set a cash professional bond. I'll inquire of my client how much money he can raise for bond. Are you guys seeking a GPS with an exclusion zone?
Yes, Your Honor. We are seeking at the very least to have a GPS applied before it's released from incarceration.
Judge, I'll ask that that be done through pretrial services. Otherwise, it's going to be probably $13, $14 a day. With pretrial services, sir, it should be $1 a day. I've already spoken to my client, instructing him not to have any contact with the alleged victim, and I believe that the state's going to ask for that as a condition of the bond.
Okay. To the state, what are you seeking?
I'm seeking, Your Honor, a reasonable bond. And when I say reasonable, I would like for the court to be apprised of all the facts surrounding the arrest and, in general, the criminal history and conduct of this defendant. The highest concern of the state about this defendant is that he is a danger to the community. The reason why I say this, he was previously, last year, on probation on 3 felony cases when he committed a new law violation of assault on law enforcement officer and battery on law enforcement officer that was reduced to a misdemeanor for the sake of a plea. So when he pled to that case, he was placed in jail for 11/29. He got out of jail after serving that sentence towards the end of July. Not even 2 weeks after his release from jail on those several felony cases, he was arrested for fleeing and eluding at high speed, a second-degree felony. The state has filed charges on that, and also making a false report of the theft of the motor vehicle. Now, the facts of this case also show violence from this defendant towards this victim. I have had an opportunity to communicate with the victim. She confirms everything that is contained in the arrest report and probable cause that is part of this court record. The defendant broke into her house. He was uninvited, and he proceeded to push her towards the bedroom and rape her. He also strangled her, kept her head on her pillow. She couldn't breathe. Finally, he left. She called law enforcement. There was DNA present in her genital areas of the victim, and then later there was a DNA match with this defendant. She denies ever having consented to the crime. However, I want the court to know that this event for which we are here today happened in 2022. It took a while for the DNA to come back, and the FDLE produced a report on it. So the state, given the criminal history of this defendant include a resisting without violence, assault on law enforcement officer, vehicle theft, aggravated assault with the intent to commit a felony, carry concealed weapon, trespassing, burglary of an occupied structure, vehicle theft, retail theft, shoplifting, resisting without violence, fraud, possession of weapon by Florida delinquent, possession of controlled substance, resist officer without violence. Based on the criminal history, the fact that right now he's facing a first-degree felony punishable by life, burglary with battery, with sexual battery, the state is asking a $50,000 cash or professional bond, no contact with the victim, GPS monitor, pre-trial services with weekly in-person check-in.
Okay, thank you. Mr. Williams?
Judge, this event is alleged to have occurred back in 2022. She, at the time, gave a rather detailed, now, what I have is what's in the probable cause statement. Obviously, the state's not complied with discovery as yet. They're not required to as yet. The 15 days won't even start counting until after they file an information in the case, and no information's been filed as yet. But in the probable cause statement, the court should note that there's no allegations in a relatively detailed statement of any anal contact. DNA samples were submitted back in 2022 to FDLE FDLE then entered the results into CODIS, and a hit came back in 2022 for Mr. Hart as a contributor to both vaginal and anal samples. And again, nothing was said about any anal intercourse at the time, back in 22 when this is alleged to have happened. They didn't even try to get buccal swabs until 2024, some 2 years later. There's no explanation for the delay in the investigation of the case for a 2-year period. And frankly, Judge, I'm considering a motion alleging constitutional speedy trial violations, because at this point, defense witnesses will not be available. They won't have a recent memory of, oh, well, these two were loving up on each other a week later when I saw them at a party, things of that nature. So buccal swabs to confirm that were taken in May of 2024. He gave a statement in April of 2024 admitting that the two of them had been boyfriend and girlfriend at the time, there had been sexual contact between the two of them, and explaining to the officer that during that time frame she got mad at him for not giving her drugs. At this point, I don't have, and she's not here to testify where I can cross-examine her on any drug history from that time frame, any arrests, police involvement for drugs, or whether or not that was even an issue.
I do have to object to this line of argument about some allegations of drugs involving the victim. I don't think it's appropriate. It's irrelevant.
I believe that's in the arrest report. I believe it's referenced.
The statement that he made is in the arrest report.
It's a statement made by the defendant, which is a self-serving hearsay that wouldn't even be allowed at trial. So that's why it's irrelevant
well, Judge,
to me.
One of the points that I'm making here, though, is she's not present. Everything that the state has said is rank hearsay. They had the opportunity to try to have her present, but she's not, and so she can't be cross-examined on that. Obviously, we're going to be, filing for, take her deposition in the case. So long and short of it is, during this entire time, he's not sought to flee the jurisdiction of the court. Even after buccal swabs were taken again in May, and he was questioned about it, he didn't seek to flee the jurisdiction of the court. It doesn't appear that he's any kind of flight risk or that there's any reason to be concerned about the safety of the victim, particularly if the court imposes the GPS with an exclusion zone. Judge, I understand the state's position, but the facts and the exigencies surrounding this case suggest that a bond that he can make would be more appropriate. There's no reason to believe that he's a flight risk some 2 years later when he was aware of it back at the latest in April when he was first questioned and voluntarily gave a statement. And now, the buccal swabs were obtained with a warrant, but he's still here. He's not running. He was at liberty until his arrest on this charge, even though he was facing other charges.
I turned myself in night before last.
All right, so if the court will allow, I'll inquire as to what kind of bond he can make or how much he can make. Sir, how much could you raise
Mr. Hart,
for a professional bond?
First off, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Sir, how much could you raise to pay a professional bondsman on this case?
$500.
So, Judge, are you working right now?
No, sir. I was supposed to start.
Okay, so this is also impinging on his, are you going to have to get those funds from family or friends?
Yes, sir.
Okay. So, Judge, I realize this is a serious charge. I explained to him when I met him at the jail that depending on how it's charged, it could be first punishable by life. He's very much aware of that. But there's no allegation, even though he's known about this and known that this was coming for months now, potentially for years. I don't know if there was any discussions back in 2022 or not. They're not reflected in the report. But he's known about this for some time. There's no allegation he's contacted the victim. There's no allegation he's tried to influence anybody. There's no allegation he's tried to flee. Judge, I'm going to ask for a $5,000 bond. Can you pay $1 a day for a GPS?
Yes, sir.
No, if I may, just correction about a point. He's not at risk of fleeing. He was charged and arrested for fleeing, law enforcement officer. After they verified that he didn't have a driver's license, they pulled him over. He pulled over.
And when was that?
This just happened in the beginning of August, 8/10. I filed an information yesterday or the day before on it.
Okay, so,
Judge, that was a fleeing and attempting to elude, and he's not alleged to have left the jurisdiction of the court.
understand. When did Mr. Hart, when was he released? You stated, the state stated that Mr. Hart was incarcerated for 11 months, 29 days. When was he released?
I'm pulling up the record, Your Honor, if you, 1 second. I want to say 7/23, 1 second, it's coming up. So, he was released on July 23rd, 2024, and he was booked again on August 10, 2024, for the fleeing.
And then was released, and he's still in custody from August 10th?
No, I believe that he was released, he paid bond on the fleeing, and then he was arrested on the sex assault and burglary.
Okay.
And Judge, he's already
I
turned.
myself in for that, because I found out I had a warrant.
Okay. And the reason why, first off, Mr. Hart, I nod a lot. When the state's arguing, I nod. Mr. Williams is arguing, I nod. It's because I understand the argument, or it's consistent with the homework that I did. Not necessarily that I agree with their argument, but I understand it. So that's first. Second, the reason why I asked when you were incarcerated is Mr. Williams argues, and I'm not saying this to you to ask you or promote you to make any responses. I don't want you to do that because everything's being recorded. States there, they can use it against you, but I want you to understand my logic. The reason why I was asking when you were incarcerated and when you weren't was Mr. Williams argues, and it's a good point, is there was an extended period of time between this alleged incident and now, and even since April and now, but it appears that you weren't out of jail for that whole period of time. And so it really cuts down the period of time that you were out. And the court does have concerns about the safety for the community and the alleged victim. The court is setting your bond at $50,000 cash or professional, appointing pretrial services. You will need to wear a GPS monitor, have no contact with the victim, either directly or indirectly. Don't ask anyone to get in touch with the alleged victim. Don't post anything online directed at the alleged victim. So when will Mr. Hart be back? He'll be back for arraignment?
He said on September 26th in front of Judge Montier, Judge.
Okay. So you'll be in front of Judge Gonteric then? Thank you.
Can I ask how the bonds are broken up since there is 2 counts?
Okay. Yes, ma'am. The first count is what?
Is the sexual assault or the sexual battery?
And what's the second count?
The burglary with assault or battery?
Let's just do it half and half.
Yes, Judge.
Okay. Good. Thank you, sir.
All right, so what that's going to do, sir, is $5,000 to a professional bond, okay? If you don't get out, I'll come see you again once I get discovered. Thank you, Judge.
Yes, sir. Thank you. And this was based on the court's motion, not on the state's motion.
That's correct, Judge, thank you.
Okay, yeah, no worries.
Yes, ma'am.
Good afternoon, Your Honor.
Good afternoon.
Rachel Farkas on behalf of Gabriel Castillo, 2024 CF 1942.
Yes, ma'am.
I do not believe that the state is at this point asking for pretrial detention.
Okay, to the state.
Your Honor, the state at this time is going to ask for a continuance until next week. We need to have the requisite 5 days to get the officers here, and we were not able to get our subpoenas out. I have spoken with the alleged victim, and I do know that she will be here next week for a pretrial detention hearing.
Okay.
So at that time, we will likely proceed with a pretrial detention hearing.
Mr. Castillo, this law only came into effect the beginning of this calendar year, and it expressly has in there the ability for the court to grant continuances such as what the state's asking, because this is a really short period of time since you were arrested and this hearing date. May seem like an eternity when you're in jail, but it's relatively short for the court. The court does grant the state's motion for continuance, so you'll be back here a week from today. Is this Judge Ketchell's or mine?
It is, Your
Mr.
Honor.
Schedule.
And if I could just, I'd like to put on the record
Yes,
my
ma'am.
objection to the continuance.
Yes,
Mr.
ma'am.
Castillo was arrested on August 17th, which, while I believe that was Sunday? I think that was Sunday. It is 5 days since the 17th. Wait, what did you say? Saturday. I'm sorry. He was arrested on Saturday. I understand that the continuance will be granted, but just as always, I wanted to preserve the objection, especially given that the state attorney has already spoken to the alleged victim. Often the request for a continuance is because they have not been able to get in contact with the alleged victim yet. But I understand if the continuance is still granted.
Thank you, Ms. Farkas. I appreciate it. Thank you, sir. So you'll be back in court a week from today. Okay, is the PD? Mr. Castillo, hold on one second. Do you wish for the state, I'm sorry, the public defender to represent you?
I forgot that we have not yet been officially appointed.
My mom, I don't know, my mom's got all my money dealing with all that right now. I don't know, she's disabled, so I honestly don't know if she's gonna be able to do it. I thought I was gonna be able to go back to work, next Tuesday and be
Right.
back for court.
Okay, so you don't want me to, here's what I'd suggest, but here's the downside to you first. The downside to you is $150 if you do what I suggest. I'd recommend that the court appoints the public defender today so they can start working on your case between now and a week from today. If you decide that you want a private attorney between now and then, tomorrow, whatever, the downside is you'll have to pay the public defender's fee of $150.
Well, I mean, I'll keep her, pay her, but it don't matter. I've never been in court like this. I don't know how to deal with it.
Your
Yes,
Honor, I'd
ma'am.
ask that for now you appoint the public defender.
Okay.
After speaking with him, I think that it's appropriate.
Mr. Castillo, it's up to you, though. It's not up to any of us. Do you want me to appoint an attorney to represent you? And then you can always hire another attorney if you want to. And they would just step in the shoes of the public defender.
So.
Or do you want to wait?
I've never done that. I ain't never been
Okay.
in court or jail.
Do you want to just wait and you talk to your mom
I'm
and
not
decide?
gonna be a lawyer. I'm just gonna keep using her, I guess. I don't know.
Okay, well, she is an attorney, so I do appoint the public defender to represent you, okay? So the public defender will continue to represent you unless you hire a private attorney, and then that private attorney talks to you, and you say, yep, get rid of the public defender, and then that'll happen, okay? Thank you, sir. So you'll be back in court a week from today.
I'll see you
Yes,
there,
sir.
okay? Yeah, no problem.
Okay, I don't think there's anything else for 12:30. Anything you want to do now before 1:30? Okay, so we're in recess until 1:30. Rachel?
All right.